Okay, let's unpack this. We're diving into a concept that feels, well, absolutely foundational to a stable society, the rule of law.
Hmm.
At its core, it's this idea that law, not just people's arbitrary will, should govern how we live together.
Exactly. And crucially, that anyone wielding power is also under that law.
It's meant to be a constraint, right?
Yeah.
Applying to everyone, the people making laws, administering them.
Right up to those holding significant power or even seeking it. They all, in theory, have to answer to the law.
It seems simple enough on the surface,
Uh-huh.
except as soon as you start, pushing on it a bit, you find there's surprisingly little universal agreement on what the rule of law really means in practice.
That's very true. And that's where our source material comes in today. We're
Hmm.
drawing heavily on Jeremy Waldron's work, particularly his writing on thoughtfulness and the rule of law.
Right, which sounds intriguing already.
It is. Because Waldron offers I think, much more demanding and, frankly, more realistic understanding of this ideal. It pushes back on some of the simpler definitions we often hear.
And there's this really fascinating tension he highlights, isn't there? The one we want to explore today.
Yes, definitely.
It's how does the very human element, the thoughtfulness, as he calls it, the judgment, interpretation, even discretion.
Which is absolutely necessary in law.
Right. How does that square with the idea of being ruled by stable, predictable, almost, mechanical law? It feels like those two things are pulling in opposite directions.
It certainly can seem that way initially. But Waldron's point, I think, is that they're not necessarily in conflict. Or maybe the conflict itself reveals something deeper about what the rule of law actually entails.
Okay, so let's jump right into that tension then. The common way people think about the rule of law. It's all about certainty, isn't it? Predictability.
Hmm. Predictability, clear rules you can rely on, applied, well, almost mechanically.
Yeah, and there's that whole tradition of listing principles.
Oh, yes, you see lists from Dicey, Raz, Lon Fuller. They all have these lists, often around 8 key features, funny enough, though the lists themselves vary slightly.
But the emphasis is usually on things like laws being known in advance, public, clear, stable.
Exactly. Prospectivity, publicity, clarity, stability, those kinds of formal virtues.
So in that view, the cleaner, the more sort of robotic the application, the better the rule of law is supposed to be.
That's the conventional picture.
And from that perspective, human thoughtfulness, interpretation, context. That just sounds like noise, doesn't it? Like it undermines the whole predictable point.
It feels like it introduces unwanted wiggle room. Like law should be applied with, quote, as little independent input from the judge as possible.
Okay, but here's the first big challenge from Waldron, right?
Yes. His first key insight is that this view dramatically
Hmm.
underestimates the sheer intellectual demand that law places on everyone involved. Judges, lawyers, administrators, even citizens trying to follow it.
It's not just pushing buttons.
Not at all. Law requires intricate thought, judgment, understanding context. Applying law isn't something a machine could ever fully do. It's not just execution. It involves reasoning, interpretation,
Hmm.
deep understanding.
Huh. So maybe thoughtfulness isn't the enemy of the rule of law? Maybe? Maybe a certain kind of thoughtful engagement is actually part of it, essential to it.
That's exactly where he's heading, and this connects directly to his critique of what he terms casual positivism.
Okay, casual positivism. Let's break that down. What does he mean?
It's basically the idea that, well, pretty much any system of centralized command and control that calls itself a legal system
Uh,
counts as one,
just because it says so.
essentially. That law is just identifiable commands coming from some sovereign or recognized source. Full stop.
Yeah.
Think Hobbes, Austin, Bentham. Their focus was heavily on power and command structures.
Right. So it's like the example sometimes used, calling a country the Democratic People's Republic doesn't automatically make it democratic.
Exactly the analogy he uses. Just calling a system of commands law doesn't mean it actually embodies the ideal of the rule of law in any meaningful sense.
So what's missing?
The crucial insight here is that for a system to count as a true legal system, one that genuinely upholds the rule of law, it needs to satisfy much more demanding criteria. It can't just be identifiable commands.
It needs more substance.
Yes, it needs to embody certain values, things like respect for liberty, for human dignity. It's not just about where the commands come from, but also about what the system does, how it treats people. It has to offer something more than just the brute exercise of power.
Okay, that adds a really important qualitative layer. It's not just form, it's also about substance and values. Now let's talk about the actual stuff law is made of. We usually think rules. But you mentioned law also uses standards.
Absolutely. That's a key point. The rule of law shouldn't be mistaken for simply the rule of rules. Law is packed with standards. Think about terms like reasonable speed, due care, excessive force, unjust enrichment.
Right. And the immediate pushback is, well, aren't those just too vague? Don't standards give officials way too much subjective power? They seem less certain than rules.
That's the standard objection, definitely. But the key insight Waldron highlights is that standards do provide guidance. It's just a different kind of guidance.
How so?
They guide individuals' practical reasoning. They don't spell out the exact behavior in every conceivable situation, but they direct you, the person acting, to think about the circumstances and figure out what conduct is appropriate.
Okay. Can you give an example? I think the source mentioned an Ohio traffic case.
Yes, that's a great illustration. The case involved a Mr. Schaefer and, tragically, a young boy named Bo Saki who was killed in an accident. Mr. Schaefer was charged with manslaughter, based partly on violating a statute that required driving at a reasonable and proper speed given the conditions.
And his defense was that reasonable is too vague.
Exactly. He argued it was unconstitutionally vague, didn't give enough notice of what was prohibited.
What did the court decide?
The Ohio Supreme Court disagreed. They upheld the statute. And interestingly, they said its very adaptability to meet every dangerous situation was actually a strength, not a weakness.
Huh. Adaptability as a strength.
Yeah. It required drivers to use their judgment based on the actual conditions: traffic, weather, the road surface, visibility. It wasn't giving a precise number, like 55 miles per hour, but it was giving a clear direction for the driver's thinking.
So the guidance is in the kind of reasoning it demands, not just a specific command.
Precisely. And you mentioned earlier the first applier.
Right, you said it's often the individual.
Yes, that's absolutely vital. When you're driving, you are the first person applying that reasonable speed standard, long before any police officer or judge gets involved. You're constantly assessing. So standards engage our intelligence. They mobilize our practical reason to figure out appropriate behavior in all sorts of varied contexts. It's a fundamentally different kind of action guidance than a simple fixed rule.
Okay, I see how standards guide thought, but isn't that concern about a chilling effect still valid? You know, people might be scared to do anything if the standard feels too mushy or unpredictable.
That's a completely fair point, and it's a very serious concern in certain areas. Think about free speech, for example. We definitely don't want vague standards chilling legitimate expression.
Right.
But Waldron notes that this objection might carry less weight in areas where the activity itself inherently requires, well, careful attention and is subject to regulation for safety, like driving.
Ah, okay. Context matters.
Exactly. Using a standard that prompts caution and judgment isn't necessarily a bad thing when there isn't some strong background, right, to just, drive however you please without considering others' safety. The baseline expectation is different.
Okay. So, beyond rules and standards, what else forms this richer picture of the rule of law? You mentioned procedure earlier.
Yes, this is really crucial. The focus shifts towards procedure and the whole institutional framework. A core insight, drawing heavily from Lon Fuller, is that the rule of law isn't just about the formal qualities of the laws themselves.
Like clarity or prospectivity.
Right. It's fundamentally about how law operates institutionally, how decisions are made.
And Fuller emphasized things like courts.
Absolutely. Fuller saw law as deeply connected to creating opportunities for people to present proofs and reasoned arguments within specific institutions, especially courts.
Arguments, reasoning.
Yes. And a key part of this, he argued, is requiring judges to actually give reasons for their decisions.
Why is giving reasons so important?
Because it shows the parties involved that their participation mattered, that their arguments, their evidence, it wasn't just ignored. It validates the process, and more importantly, it respects the dignity of the people involved.
It makes the whole thing feel more legitimate, more respectful, less like just being told what to do.
Exactly. And this connects to another important idea from Neil McCormick. He described law very powerfully, I think, as fundamentally an argumentative discipline.
An argumentative discipline. I like that.
It's not just about state commands backed by force, which is the simpler positivist picture sometimes. It's about people arguing over the meaning of norms, interpreting them, applying them to new, often tricky situations.
Which, again, sounds very different from law being some kind of mechanical, unthinking process.
It really does. And the key insight here, according to Waldron, is that this culture of argument isn't just incidental. It's something a genuine legal system actively sponsors and institutionalizes.
It builds it in.
Yes. And he criticizes some forms of modern positivism for often missing this whole dimension entirely, for focusing almost exclusively on the command and control aspect and overlooking this vital culture of argument.
And you can really see this focus on argument and procedure playing out in real-world rule of law debates, can't you? The source mentioned the concerns around detainees at Guantanamo Bay.
That's a perfect stark example. The demands made there, framed explicitly in the name of the rule of law.
Right.
They weren't primarily about demanding a specific law saying, you cannot detain these individuals.
What were the demands then?
They were overwhelmingly about fundamental procedural rights. The right to a hearing, the right to see and confront the evidence against them, the right to have representation, and critically, the right for the authorities to provide reasoned justifications for continued detention.
So it was about the process of decision-making.
Precisely. These procedural demands, having your case heard, being able to argue, demanding reasons, these are absolutely core to what people mean when they invoke the rule of law in practice. It's not just about having clear rules on the books.
And this ties into treating individuals respectfully, right? Not just as objects of state power.
Exactly. It treats them as, in Waldron's phrase, active centers of intelligence, people capable of understanding, questioning, and responding to the rationale behind how they are governed or treated.
It's about engaging with their capacity to reason, their dignity.
It's deeply connected to dignity.
And you said this also links back to that idea of self-application we talked about with standards.
It absolutely does. Thinkers like Hart and Stacks wrote about this technique of self-applying regulation. In most everyday situations, you are the first person applying the law to yourself.
How so?
Well, you read a contract before signing it, you figure out traffic rules when you drive, maybe you draft a will according to legal requirements. You're constantly interpreting and applying legal norms in your own life.
Usually before any official, like a judge or police officer, ever gets involved.
Right. And the key insight here is that this technique, relying on individuals to apply the law to themselves first, is deeply tied to respecting human dignity.
How?
Because it treats you as a capable agent, someone who can understand complex norms, interpret them in context, and act accordingly using your own practical reasoning. It doesn't assume you need constant direct supervision for every little thing.
Although sometimes you do need an official determination.
Of course. Some things, like, say, getting a divorce or settling a complex property dispute, clearly require an official judgment, because self-application alone isn't sufficient or appropriate. But the first reliance is often on the individual.
Okay. How does something like stare decisis fit into this richer picture? The practice of courts following precedent. We usually hear that's just about predictability.
Predictability is definitely part of the story, no doubt. But Waldron, drawing on others, argues the deeper connection to the rule of law is less about mere predictability.
Okay.
And more about upholding the principle of being ruled under the auspices of general principles.
Ruled under general principles. What's the nuance there? What does that mean practically?
He describes it as a kind of layered approach, or a shared obligation. The first judge deciding a novel case has an obligation not just to resolve that specific dispute between those parties.
But to do more.
Yes, to articulate the reason for their ruling as a general principle, one that could potentially apply to future similar cases. It has to be framed generally.
Okay, so the first judge sets out a general principle. Then what?
Then subsequent judges dealing with similar cases have an obligation to credit that previously articulated principle, to treat it as a relevant source of law, maybe even a binding one depending on the system.
So it's like Rule 1, make a general principle when you decide. Rule 2, follow the general principles others have made.
That's a good way to put it, yes. And the key insight, particularly emphasized by thinkers like Ronald Dworkin, is that this whole practice isn't just about convenience or predictability. It's seen as a core rule of law requirement for judges.
A requirement on them.
Yes, to constrain themselves, to ensure they are deciding as a court, bound by the law's evolving principles, rather than just imposing their personal views or sense of justice on a particular case. It's about maintaining continuity and coherence with the law itself.
Interesting. It makes precedent seem less arbitrary and more about institutional discipline.
Exactly.
Okay, let's shift gears slightly. There's this common distinction people make. The rule of law versus rule by law. And usually, rule by law gets a bad rap.
Yes. It's often used pejoratively to describe authoritarian regimes that, use laws instrumentally as tools of control, without feeling genuinely bound by them.
So they create lots of laws, but maybe apply them selectively or inconsistently or even retroactively just to maintain political power.
Precisely. And the source material does note this is a concern regarding, for instance, current analyses of Chinese-style legal authoritarianism, that law is used primarily for control, not constraint on the state itself.
So is rule by law just inherently bad then? Is that the takeaway?
Well, here's another interesting insight from Waldron. He actually pushes back against dismissing rule by law completely out of hand.
Oh, how so?
He argues that rule by law, if you take the phrase at face value, can actually describe something potentially positive, or at least better than the alternative.
What could be positive about it?
It could describe a regime's admirable willingness to subject itself to the formal discipline of legality,
Yeah.
even if it's not fully constrained by external checks.
Meaning, they actually bother to make laws that are clear, public, perspective, stable, and then generally follow them.
Exactly. A commitment to those formal qualities, generality, clarity, prospectivity, publicity, stability, even if the rulers aren't ultimately subject to, say, enforceable rights enforced by an independent judiciary. That still has moral significance
Why?
because it pays a certain respect to human agency. It provides a predictable framework that people can use to plan their lives, which is vastly preferable to rule by sheer, unpredictable terror or completely arbitrary decrees.
So it's maybe a weaker constraint than the full rule of law ideal, which might include things like judicial review.
Right. It lacks that external accountability, perhaps.
But it's still a form of constraint, and better than nothing.
It's definitely not nothing. It's a commitment to governing through law-like forms, which has value in itself. It's just different from, and perhaps less demanding than, the ideal of the rule of law, where the law is supreme over the rulers too.
Okay, that's a really useful clarification. It's not black and white. Now, speaking of lawmaking, sometimes you sense an underlying tension, maybe even hostility, between the rule of law ideal and legislation, especially in some traditions, like Hayek's maybe. There seems to be a preference for judge-made common law, which emerges organically, over statute law made by legislatures, which can feel more managerial or top-down.
Yes, that perspective definitely exists, and it often aligns the rule of law primarily with protecting private law domains, property rights, contracts, creating a stable investment climate.
And sees democratic legislation as what? A potential threat?
Sometimes, yes.
I know.
As potentially interfering with those established private rights or market values. This view got linked, rightly or wrongly, with aspects of the Washington Consensus promoting market liberalization.
So the rule of law becomes mainly about shielding markets from democratic collective decision-making.
That's one interpretation, yes. But Waldron strongly defends what he calls the dignity of legislation.
The dignity of legislation, what does that mean?
His key insight here is that legislation is a primary, transparent, and legitimate way for a community, especially one organized democratically, to collectively take responsibility for the conditions of its members.
It's how we actively shape our society.
Exactly. It's how we address issues like rising inequality or the need for new public goods, or how we regulate negative externalities like pollution, things that often require deliberate, forward-looking collective action that common law might struggle to achieve on its own.
Things that require a society-wide perspective.
Precisely. Law has to make space for society to collectively notice problems and adjust its framework through legislation. That's the perspective of a citizen living within the society, not just, say, an external investor looking only for stability.
So the rule of law shouldn't be biased against legislation.
No. The rule of law needs to apply to public administration and legislation just as much as it applies to private law. It has to accommodate public interests and collective goals alongside protecting private rights. It's a framework for all governance, not just courts and contracts.
Which brings us, I suppose, to one of the thorniest areas in modern rule of law debates: judicial review.
Yes. The big one.
Does empowering courts' unelected judges to strike down laws passed by elected legislatures or to review government actions, does that actually uphold the rule of law? Or is it just swapping the rule of men for the rule of judges?
That is the incredibly difficult question the source material highlights, and it's not a new debate. It goes way back. Think Hobbes versus constitutionalists like Hamilton.
Because, as we said, judges aren't just automatons, are they? They interpret, they develop common law, they inevitably make law to some extent.
Exactly. So the question becomes, are they truly constrained by law in the way we expect other officials to be? Or does their power allow too much room for personal philosophy or political leaning?
And the source mentions that very candid discussion within the U.S. Supreme Court itself in the Planned Parenthood v. Casey decision.
Yes, where the justices openly worried about the court's own legitimacy, about the public perception that major society-altering decisions might appear to depend solely on the individual political preferences of the judges sitting on the bench that moment.
Which, if people believe that, really corrodes the whole idea of being ruled by law, not by individuals.
It absolutely does. It strikes at the heart of the matter. So the key insight here is really acknowledging that the relationship between judicial power, especially strong judicial review, and the rule of law ideal is profoundly complex. It's contested.
There's no easy answer.
There really isn't a simple, universally accepted conclusion about whether or exactly how judicial review fits neatly into the rule of law ideal, especially when judges are perceived, rightly or wrongly, as acting like policymakers or being driven by personal conviction rather than legal principle alone.
Wow. It really does paint a much richer, more textured, and frankly more challenging picture of the rule of law than the simple definitions we started with.
And it's crucial to remember, as Joseph Raz famously argued, the rule of law isn't the only political virtue. It's not the sum total of all good things in a society.
Right. It's one ideal among others.
Yes, it exists alongside other crucial ideals like democracy, human rights, social justice, economic freedom. And societies are constantly trying to navigate the balance, the potential tensions between these different equally valuable goals. The rule of law has to find its place within that constellation.
So, stepping back then, if we had to summarize the core takeaway from this deep dive, especially drawing on Waldron's perspective, it's that the rule of law is far more complex, more dynamic, and much more fundamentally human than those simple models suggest, the ones focused only on certainty and mechanical rules.
Absolutely, that's the heart of it. It's an ideal that necessarily incorporates thoughtfulness, interpretation, judgment. It relies on robust procedural guarantees, on institutionalized argumentation.
And it respects human agency.
Deeply, both in how laws are applied and in how they're made. And it has this intricate, sometimes difficult relationship with different forms of power, legislative power, judicial power. It's not simple.
So here's a final thought for you, the listener, to mull over. If we take seriously this idea of law as an argumentative discipline, one that relies on thoughtfulness and interpretation, not just a static list of commands, how does that change the way you think about your own relationship with the law? In your everyday life, where do you notice those moments? The times when the law seems to invite your judgment or requires you to use your practical reason, or even implicitly asks you to engage in understanding and maybe even argument, rather than just simple blind obedience.
It's an interesting lens to apply.
It is. Where does law ask you to think? That's definitely something to chew on.